Hello, everyone. Dorud bar shoma. So the reason you're here is that your visa application, your immigration permit application, has been refused. If that's the case, you are in the right place. Now, I'm here to explain to you very briefly how this process works. We have extensive experience in overturning applications that have been refused, whether it's temporary residence visas, whether it's work permits, business visitor visas, business work permits, international mobility programs, or permanent residence applications. We have a track record of overturning these refusals at the federal court. This is how the process works. So from the start, when we register your notice of application at the federal court, according to Rule 9 of the federal court, it must be around 30 days before we receive what we need, which is the reasons of the officer's notes for refusing your application. Immediately after we receive this, we start working on our submissions, on our application records, and we have 30 days. So it's going to take another 30 days in addition to the initial 30 days in order to submit that. So there's a very good chance for your application at the federal court for judicial review to be successful in month 3 or 4. So a lot of applications in months 3 and 4 get settled with the Department of Justice, which is basically representing the Immigration Canada. So a lot of these applications get settled and then are remitted back to Immigration Canada for a redetermination process, which is a process in which a new officer is assigned to process your visa or your immigration application. If that's not happened to you in your case, then the Department of Justice will send a memorandum of argument on behalf of the respondents, which is Immigration Canada, in which case the whole file goes to a federal court judge. In that case, there are two options. One is the judge issues leave, which means that there's going to be a hearing to be set at the federal court, or the application might be dismissed, in which case there's nothing we can do. But the good news is that there's about less than 5% in our case. At Bigdelilaw, there's less than a 5% chance, according to our historical record, that your application might be dismissed. So that's the good news. So there's a more than 90% chance that if you haven't been settled in the earliest stages of the first 3 or 4 months, your application must be granted. Application for leave might be granted, in which case there's going to be a hearing date set. But in a lot of cases, the hearing that might be set for month 7, 8, 9, or 10, that is our current data, our current experience. Again, the Department of Justice might settle your case and remit it back to a new officer for redetermination. So it might not even make it to hearing. Very small percentage of the cases will end up actually at the court. So this is the process. You have to keep that in mind. Just to wrap it up, that the whole process might take between 3 to 4 months, all the way to even 1 year or more. But a lot of cases, as I said, get settled within the first 3 or 4 months. Add to that the process of redetermination back at Immigration Canada or IRCC, which might add a month or 2, or in sometimes a little bit longer. We look forward to help you in this process. Just talk to one of our intake specialists to see what we think your chances are for success, so that you are one of the successful clients that we've been represented in over the past year, and we can help you overcome this challenge and hopefully get your permit or application granted.